So it sounds to me like you want to use the contract analogy to limit the scope of this argument, because you keep saying, well, no, this is privity, and that's why we don't need to take a position on whether it would reach a member of the general public, right? But then you're moving away from the contract analogy when Justice Gorsuch is asking you about, well, do these principles of contract law apply? I don't understand. It seems like we're slipping in and out of the contract analogy.
Yeah, so let me try to be clear, Justice Barrett. I think that the contract analogy applies to determine whether there's notice. I think this court's cases are clear that the notice that matters is the state's notice. I do think that the officers can be fairly held to account for notice here. I think under the spending clause alone, this is an easy case because officers consent to work at a federally funded state prison. I think when we add in the necessary and proper clause, you know, the farthest this court has ever gone is Sabry, which reached a member of the general public. There was no consent there. I think that the necessary and proper clause allows Congress to enforce valid conditions. There may be hard questions about can Congress impose the condition in the first place? But I think once Congress has imposed the condition, and again, respondents don't dispute that they're bound by the substantive RLUIPA condition, and courts of appeals have upheld the substantive condition under the spending clause, Congress can go one half step further and enforce it against individuals.
But that half step has to include members of the general public, because you're relying not just on the contract, because the answers about the contract are that it does not need to give clear notice to the employee. So they're getting their notice from the statute, right?
Yes, I think they have notice from the statute. And again, I think qualified immunity is an important backstop for officers. I guess with what I would say about members of the general public is I think conceivably, and the reason we're not taking a position on sort of how this non-party liability issue cashes out there, because I think there conceivably could be different analysis under the necessary and proper clause. I think here it's necessary.
What would that analysis look like?
Well, so let me just walk through what the analysis is like for individual officers, and then as I'm doing that, we can sort of see how it'd be different. But here, it's necessary to enforce it against individual officers because otherwise the condition would go unenforced in a significant category of cases. And the facts as alleged here are a good example of that. Facts of one-time abuses.
You can finish your answer.
Thank you, Mr. Chief Justice. That Congress clearly had on its mind in RFRA and RLUIPA, you know, the destruction of a Bible, et cetera. It's also proper because this is a long-standing traditional remedy, and it's against state officials who are most likely to violate the condition. These are the people through whom the state acts. The state otherwise doesn't act but through its officials. And so I think that necessary and proper analysis could look a lot different when we're reaching a member of the general public, and I think there could be other safeguards. I mean, there are other limits on spending clause power too, and I think those would equally apply.
Thank you, counsel.